Alex here with part 123 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed and cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. This video goes into my reply to opposition to my ex's motion. Well, actually, my reply to my ex's opposition to my motion to order to show cause regarding contempt. We just went over that in the previous video. And I suspect I probably address all of the points that she's raised. I can't remember, just like the previous several documents in the series. These are filings that I can't remember in detail, and then I'm probably going to get a better recollection as to my mindset when I go through the document. So, all of that being said, let's go ahead now and take a look at what I have filed. Here we are with my reply to opposition to motion. Standard introductory paragraph. I introduce myself as the petitioner, indicate to the court that I am appearing in proper person without an attorney, and that I am replying to my ex's opposition. Standard summary. Oh no, wait, this is not a standard summary. I go straight into addressing each of her assertions. So, the first one is that my ex's bad faith precludes excusal of her conduct. So I'm basically trying to say that she's admitting to violating the court's order and that her reason constitutes a bad faith reason, and therefore she should still be punished and held in contempt of court. So I'm trying to keep the court on track here. So I'm saying here that my issue is not solely due to my ex's violation of the court's August 26th and May 10th orders, but in combination with the fact that she did so deliberately intending to exclude me from attending those appointments. Had my ex given me telephonic notice of the 2 recent dental appointments, as I did for my ex when... See, it doesn't seem like my ex's attorney and the judge understand the golden rule. Do unto others as you would expect them to do unto you. Anyway, there were a couple of emergency situations with my ex, and I gave her telephonic notice, and there was an ER visit, stuff like that. No, she's not going to do that for me because she doesn't have to. She's got an attorney who covers for her, and apparently a judge too. Going into the next paragraph, I did not get an email on my phone. What's especially troubling about this is it's the first time I've heard any mention of it. My ex has never stated or implied that my phone receives email directly. If she was seriously under that impression, why wouldn't she have raised this point? This is a good point that I'm making. If this was a reason, legit reason as to why wouldn't she send it in an email? And the reason is because she didn't think of this as an excuse. You know who did? Her lawyer. Her lawyer probably did. Her lawyer probably gave her that excuse and typed it right into the opposition. So, going into... So yeah, 11 hours notice. It wasn't a half hour. I don't know why her attorney said half hour. It's still too short because it's 11 hours overnight. So, I mean, she sent the email at, I think it was 9:30, maybe 10:30. And then the appointment was in the morning at 8, something like that. In any event, this is me just reiterating the email. And my response, okay, wait. This response acknowledges my understanding of the urgency and requests that my ex in the future contact me. Oh my gosh, I got her again on another thing. So, apparently there were other emergency appointments where she didn't give me notice. I asked her to call me. She didn't do it. I didn't file a motion. I just let her get away with it. And then what's her response? She does it again. She does it again. This time I file a motion, and what is her response? It's not, oh man, I messed up a second time. No, it's, hey, he's litigious and he's trying to harass me. again, I mean, the information is right here for the court, and I'm getting just it's go back right back to these same days where I just have a judge who could care less, or it's possible that he cares very much, but that he's trying to actually manipulate the proceedings in the direction of my ex's attorney anyway. One of them is far more insidious than the other. I would like to think that he's just clueless and doesn't know how to do his job, rather than that he does know how to do his job and he's manipulating the outcome of the case in a malicious way. But anyway, I mean, given this evidence, you're going to expect the hearing to go a certain way, and it's just not going to go that way. The judge is just he still doesn't get it. It's nice that he orders my ex in contempt of court, but I remember still all of the other stuff around that, and he just doesn't get it. And in fact, I think most of what he does can be attributed to the wrong-headed approach I described in the video, meta rulings. Anyway, let's move on. Okay, my ex's contention is that I am looking for ways to find conflict. Okay, yeah, because then if that was true, I would have filed the motion the first time she screwed me out of going to an appointment and didn't, and I mean, there apparently, let me see this one really quickly. Short notice is okay in an emergency. Please use the phone, blah, blah, blah. Okay, so it's either one time or two times. In any event, at least once she does it and she gets away with it and I don't file anything. So if I'm trying to find conflict, then I would have filed a motion when she did that as well. Instead, I took it as an opportunity to try and tell her, please in the future call me. And then she responds predictably by doing it again. Moving on to the next section. My ex's allegation that I failed to give her full information of a dental appointment is false. What? This isn't a defense to contempt anyway. So this is irrelevant. Again, I've talked about this before, guys. You can't. Okay, so if you're accused of contempt of court, it is not a defense for you to say they're in contempt of court too. That is another motion. So if you have a motion that's trying to hold you in contempt and you think you have a defense that is your ex is also in contempt, that's not a defense. Get that out of your head and file a separate motion trying to hold them in contempt of court. That has happened before. Judges deal with that accordingly. And sometimes judges will say, you know what, I'm not going to hold either of you in contempt. Sometimes judges will say, I'm just going to hold both of you in contempt. But you can't go into court without filing anything and say, my defense to violating the court order is that he violates the court order. That doesn't work. Well, I guess maybe with some incompetent judges it does. But from what I have heard, most of the judges don't, buy that as a defense. Moving into the next section. My ex's allegations that I took the child to an out-of-network provider and failed to pay my portion of the bill, even if true, is not a legal basis for excusing blah, blah, blah. So this isn't true, by the way, but I'm just saying what I just said earlier. Service of process complaints are meritless and inappropriate as they invite the court to comment on pending litigation. Oh my, she brings this up too. I don't remember her bringing this up. I must have glazed over it in the last video, guys. Okay, so I remember this now. And I think it comes up at the hearing, but I can't remember for sure. So my ex is trying to claim that I am harassing her by filing a petition for writ of mandamus when the Supreme Court said so. And so my response here is that her complaint is meritless and it's inappropriate because it's trying to get this judge to comment on pending litigation that is currently before another judge. So yeah, that's totally out of line. The attorney should have known better. Here we have my ex's abusive process claim, which is meritless and improper. An abusive process claim should be filed as a separate civil action for money damages. So I know how it works. My ex's attorney doesn't know how it works. The judge knows this too, and it doesn't go anywhere. Oh, yeah, this is fun. So apparently my ex's attorney is trying to use settlement negotiations in her actual opposition. I can't remember this as well. I probably went through it too quickly. I'm not sure what's going on with it, but I do remember this happening, and I do remember this being brought up at the hearing, and the judge does shut it down because the judge knows that the attorney shouldn't be doing this. I have a video on this, guys. It's titled Settlement Negotiations Not Admissible. When you and your opponent are trying to work out a deal, you are not allowed to take those negotiations and use them in litigation, because if you do that, what you're doing is you're setting a precedent that any good faith efforts to communicate are just going to be used as weapons in upcoming litigation. And the Supreme Court of Nevada, at least, does not want people to be dissuaded from settling cases. It helps the judicial system because it takes a lot of work off their plate. So the last thing they want to do is punish people for trying to work things out by allowing their opponents to use those communications in open court to win the case. So they have a lot of precedent in Nevada that says that you cannot do this. If you guys are in negotiations, if you're trying to compromise, if you're trying to settle, and you guys, discuss things, you can't use each other's words later on in the litigation process. That's considered confidential and it stays out of court. And the reason for that is they want people to feel comfortable coming to the negotiating table and working things out. This isn't the first time I've seen this happen. There's another knucklehead that does it. It was a landlord, and I mean they don't know. Like, I feel like exploitative, manipulative people, they just see everything as a weapon. They don't know how to constructively work through problems. And so just like everything else that they look at, they see settlement and negotiation as yet another weapon. And so they're not really trying to work things out in good faith. They're not trying to compromise with you and communicate constructively. They're thinking, what can I find here to use as a weapon to stab him in the back with when we go to court and win? So same thing in that case too. I might do on my docket series on that case when I finish this, but we still have a long way to go here. Moving on to the next section. By using my settlement efforts against me to create or prop up my ex's defense on opposition, she's destroying any incentive to settle in the future. The court should make clear that this tactic is unacceptable. My ex's contention is that she offered me the notice he claims is seeking is false. My ex demanded the involvement of a designee to act as a third-party intermediary, an element which I vehemently opposed. Specifically, I proposed that I would stipulate to the following language. This must be what I wanted in the court order here. There's no reason to involve a designee. Okay, so apparently my ex wants to involve a designee in our communications, which we're already doing. My ex has utterly failed to do this. Okay, so here's what I remember. This gets brought up at the hearing. And my defense at the hearing is she's going to use this to get out of contempt of court. And the judge looks at my ex and he says, just so you know, if I order this, you can't use it to get out of contempt of court. You're going to be punished if your designee screws up. And my ex insists that she's not going to do that. So the judge orders it. And guess what my ex does? Not long later, oh, my designee didn't tell me. You can't hold me in contempt of court because I didn't mean to violate the court's order because my designee just forgot to forward the message. So anyway, I don't think that works. I know she tries it, and it makes me laugh because it's just like, I told you, I warned you, and you didn't listen. This isn't the only judge to do this. The next judge that takes the case does the exact same thing. I warn her about the exchanging of the clothing. She doesn't listen to me. 3 or 4 motions later, the judge is so bombarded by contempt motions that she's like, okay, I was wrong. Never mind. Don't do that. It's like, I've talked about this before throughout the series, but one of the biggest problems with dealing with family court judges is that they do not listen to you. And sometimes I feel like they just talk at you. They don't even talk to you. They have these canned statements that they regurgitate in every hearing. And then they talk, and they make it seem like they're talking to you, but they're not really talking to you. They're just talking at you, and they're not listening. And they make these mistakes over and over again. And you're going to see this in this case, and you're going to see this with this judge, and you're also going to see it with the next judge as well. So hang in there because this case is about to get wild. Let's go into the next section here. Setting aside minor adjustments to the proposed language, the main reason I oppose the use of a designee is because it would create a legal vulnerability for my ex to exploit. I mean, it's in black and white. I type it up. I tell it to them. I don't know what else I can do to get them to listen. But you guys are going to see that this is something where not only am I telling the court in writing and verbally, but I'm also giving footnote after exhibit after citation. And I don't think they read any of this stuff. That's one of the reasons why I talk about that in, I think, the video, the judge does not remember you. That they don't usually read much of this stuff. Maybe they read like a Cliff Notes version that one of their assistants puts together, but I don't think the judges really go through these documents. Going into the next document, or next page, instead of requiring a designee, the court should order strict telephone communication. This is what the court should have done in the first place. I don't know why they haven't done this yet. But he does eventually order our family wizard, and that is... Actually, no, it's not him. It's the next judge. The next judge orders it, and that is one of the best things that could have happened in this case. Conclusion, which is just going to summarize the entire reply. Declaration in support. This is just me verifying that all the facts asserted in this document are true and correct under penalty of perjury. Rule 5, certificate of service indicating that I served this personally upon my ex's attorney at her law office. List of exhibits, 1, 2 emails. Let's take a look. Exhibit 1, first email. Let's start from the bottom. Let's follow the time. Okay, so right here. Is this the bottom? This looks like it right here. Okay, so 2 to me. I guess this was sent by my ex. My ex is telling me she has an appointment with the dentist at 8:30 a.m. She got a lot. Okay, so we've gone over this before. Next one here. Short notice is okay in case it's an emergency. Please use the phone. Get somebody to text me because I got this email in my spam. Okay, so this is me saying, please give me the respect that I give you in urgent matters. Look at this. I mean, it's in plain black and white. Did the judge read this? Probably not. He probably didn't read this at all. Anyway, this is me giving my ex a break, which is one of the things that she says I don't do. So my reward for giving her a break is for her to just do it again. And this is one of the reasons that I tell people in the video, fighting makes it worse. That fighting doesn't actually make it worse. That the person that you're dealing with is a predator. And when you give them, the benefit of the doubt and you cut them slack, they don't see that as, oh, thank you for doing that, I'm going to be nice to you now. They see that as a vulnerability and they exploit it. So they see you as a weak person and they think, okay, this guy's not going to do anything, so I'm just going to do it. It just drives them to abuse you even more. Moving into the next section. Okay, so this is her nonsensical defense, which I know I've gone over before. I feel like I've already gone through this email. Let's go to Exhibit 2. And let's start. Okay, so this is just my response to, I remember now. Okay, so she says I need to give her the address and phone number. And I remember earlier in the other video mentioning that I could have done a passive aggressive thing and like given her a screenshot of a Google page. I didn't do that though. Here you go. I just sent her the address, the phone number, and that's that. So this was the appropriate thing to do. But I mean, I just wanted to mention I do have those instincts sometimes. But then, I'm glad I didn't, because that would work with somebody who didn't have a clue. And my ex does have a clue. She's not a person who is just, oh, I don't know what's going on, I'm just completely clueless and please help me. She is a person who knows exactly what's going on, and she deliberately communicates in a way that tries to bait or trigger a specific response from you. And I talk about that in the video communication, and Sam Vaknin talks about that in the video, language as a weapon. Next section. Next page, or document. Request for submission. You guys have seen these probably 100 times by now. If you want to learn more about the request for submission, please watch the video request for submission. And we have a Rule 5 certificate of service, of course, just like the other one, indicating I personally served this upon my ex's attorney. Next document. Okay, guys, this is a general financial disclosure form filed by my ex. Because this is not my document, I am going to go through this document. I'm just going to scroll through it. I have nothing to say about it. Nothing jumps out at me. What I will say is that it's heavily redacted. And that's because I want to respect my ex's privacy. Unlike me, she is not a part of this channel. And so, whereas I am willing to show you guys everything, I don't think it's right for me to show you all of her private stuff. And so it's heavily redacted. I looked through documents. If anything jumped out at me as a concern, I would have probably brought that up to you guys. I would have scrolled to the page and brought it up to you guys. But as I mentioned, I went through it. I mean, I'm sure there's some issues that I could have made out of this document, but I decided that most of the issues were like on a scale of 1 to 10, they were like a 1. So, or maybe a 2. And so any issue that I would have made out in court, while it would have been appropriate to do it, I doubt it would have gone anywhere. The information that's not redacted typically has to do with like the number of hours that she worked, or the expenses that she was claiming. These things aren't really private, but like her bank account information and her actual pay rate and her hourly wages and all that stuff, I kept that. I blacked that out. I also blacked out like her bank information, stuff like that. So the only thing I think you're going to really get from those pay stubs and stuff like that is just like the expenses that she's claiming and the number of hours that she worked, stuff that really isn't that private at all. Going into the aftermath, I filed, it looks like 2 documents, and those were both free filings, so I incurred $0 in costs. My ex's attorney filed 1 document that was also a free filing, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, I don't think she would have spent much time on the reply because, as I've mentioned with previous reply briefs, nothing has to be filed afterwards. There's no more work for the attorney to do at that point in time. She may glaze over it at the hearing, but if she does, I'm going to just lump that time into the hearing prep rather than put it at this point. So I'm going to say just to give it a cursory glance, It was somewhat lengthy of a reply. There were some emails attached, so I would have said 5 minutes, but let's go ahead and say 10 minutes. The general financial disclosure form, that would have been much more substantial. The attorney has to go through that with my ex, or at least review it. So I think that that document could be a 20-minute document, considering all those details, which is going to take it to 30 minutes. The request for submission, I'm just going to say 0 minutes, because it's just one of those ancillary documents that the attorney isn't going to really care about. They're just going to file it into their system without even reading it, probably. So that's a total of 30 minutes for my ex's attorney. At the rate of $250 an hour, that's going to come to $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.